Analysis. Breakdowns. Legal insights.
Hold on, this is where things get serious fast. The prosecution isn't just opposing a motion. They're about to argue that these kids are in active danger. Pay close attention here, because what comes next could completely shift how this judge sees the defendant, not just as someone who made a mistake, but as a potential ongoing risk.
I think they're more equipped and better equipped to do that.
Thank you, Mr. Booth. Mr. Wirgo, people's position.
Your Honor, the people aggressively oppose defendant's motion. Defense has stated that but for this case, she'd have the kids. I would disagree and say, but for the way she framed this case for the folks down in Macomb, she would have her kids. Because, Your Honor, last week, it baffled me after seeing the video of one of her children was the minor that was present for that, that anybody would be considering this. I have since sent the video to the worker that is handling that. They have reversed their position. They are in favor of her not having any contact with the children. Your Honor.
This is the turning point. The prosecutor just introduced something incredibly powerful in court: video evidence and a child's emotional reaction. That's not just legal argument anymore. That's visceral. And here's the key question. Does a short anger management program outweigh what appears to be repeated harmful behavior? Because in family-related cases, judges prioritize one thing above all: the safety of the children.
And the boy wails. He begs her, because he knows it's happening, and she does it anyway. 6 weeks of anger management doesn't fix that, Your Honor. Those kids would be in danger if she were allowed to see them. She's already violated the order. Your Honor, please do not change those bond conditions, and do not let her have contact.
I mean, that did happen. She just pled to it, so she's not contesting.
About in the summer of 2019 or the summer of 2020, were you residing in the city of Rutgers City?
I was, sir.
And at that time, you had a daughter living with you, is that correct?
I did, Your Honor.
And,
sir.
And how old was she?
I want to say about 8.
8. And you were also taking care of a young boy, is that correct?
Yes, sir.
And how old was that child?
Around 3, 4.
So on or about, I guess, the summer of 2019, you have that boy. Were you taking care of him for his mother?
Yes, sir.
And at that time, did you lose your temper as a result of something that boy did?
I did.
And in the process of losing your temper, did you swear at him loudly, repeatedly?
I did.
Did you yell at him repeatedly, loudly to shut up?
Yes, sir.
And at one point, hard 4 times. Your Honor, I think that's a factual basis.
And that was committed in the presence of the other child as well?
Yes, I'm sorry.
Okay.
You want to say that?
Yes.
Okay. All right, you satisfied with that factual basis, Mr. Virgo?
Yes,
Mr. Charles' charges. Okay. And Ms. Fisher, in 393 FH, how do you wish to plead the charge of absconding or forfeiting a bond?
Guilty, Your Honor.
So in the child abuse case, you were on a bond given by this court?
I was.
And as part of that bond, you had to appear for court as ordered, is that right?
That is correct.
And did you fail to appear for court hearing?
I did, sir.
Okay, and then you did no longer lived within the confines of Prescott County, is that right?
That is correct.
Okay. And then you were arrested on that violation of your bond. What year?
It looked to me like the court, her bond was.
Okay, so Ms. Fisher, as a result of you not appearing at a court hearing, did the court enter an order forfeiting your bond then?
Yes.
Okay.
Yes.
All right, and you haven't contested that bond forfeiture?
Not understanding.
You haven't challenged that forfeiture of your bond?
No, we didn't.
No.
Okay. You didn't come in and file any motion to say like,
No,
you shouldn't have forfeited my bond. I didn't have
No,
notice of court.
I came in and the bond was revoked and then you set me a new bond.
Okay.
If that makes sense.
Yeah. All right. Mr. Wirgo, you satisfied with that factual basis?
Yes.
Mr. Vogler, are you aware of any other promises, threats, or inducements for this plea?
No, I'm not.
Mr. Wirgo?
No, Your Honor, there are no.
And Mr. Vogler, in your judgment, has the court complied with the requirements of MCR 6.302?
Yes.
Mr. Wirgo?
The court has.
She signed a delegation of parental duties to her sister, so the children are actually in her sister's care. She has undergone from the very beginning, way back in 2021 when she was first arrested and started out with another lawyer. She was in counseling and she went through a 6-week anger management program, which she successfully completed.
Happened, but the fact that happened doesn't mean she never gets to see her kids again for the rest of her life, right?
No, it doesn't, Your Honor, but we need
So
more.
how many years got to go by before we?
Not years, Your Honor. Counseling, therapy, real work, not a 6-week anger management class, Your Honor.
Your Honor, if I could just respond.
Sure.
In all due respect to the assistant prosecutor, the court, first of all, DHS has had this video in their possession since 2021. The fact that it may or may not have gone down to Macomb County DHS, that's problematic on their end. However, if this DHS worker, who is new to the case, as I understand it, has that position, she is in her rights to go to the family court in Macomb County and change it. And that court is way more.
And just like that, the judge makes a decisive move. Bond revoked, custody ordered. That tells you everything about how the court is weighing risk versus rehabilitation. But here's the real cliffhanger. What happens at sentencing? Will this be a second chance story? Or the moment everything finally catches up to her?
Going to be way more informed and have way more knowledge and be in a better position to make a ruling there than I think this is.
All right. Well, here's what I'm going to do. I did reset a bond that Ms. Fisher was unable to post. Now she has pled, and one of those was for an absconding as well. Post-plea bond is discretionary with the court. I think there are a lot of moving pieces that I want to hear about to determine, what the proper sentence is going to be. So what I'm going to do is in these files, I'm going to enter an order that her bond will be revoked and she'll be in custody of the Presque County Sheriff until further order of the court. We'll see you on May 11th for sentencing.